Good morning. Today is Tuesday, January the 8th, 2019. It's 10 a.m. It's my pleasure to call to order today's meeting of the Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Ms. Bohannon, will you please call the roll?
Dennis Bridges.
Here.
Robert Davis.
Here.
Jeff Duffer.
Here.
Clark McKinney.
Here.
Charles Rahm. Robert Shackelford.
Here.
Mr. President, 5 of the 6 board members are present.
Thank you. Next item on the agenda is to review and adopt the meeting agenda.
So move. Second.
All in favor?
Aye.
Any opposed? Motion carries. Next item, or housekeeping, is to provide us parliamentary procedures with the adoption of the Robert's Rules of Order. Do we have a motion?
Motion to adopt Robert's Rules of Order. Second.
All in favor?
Aye.
Any opposed? Motion carries. Ms. Bohannon, you have the conflict of interest statements.
Yes, I've passed them out to all the board members, and they've reviewed it, and everybody signed and turned those in.
Thank you. Next item will be the minutes to review and approve the December the 11th, 2018 board meeting minutes.
Make a motion to approve the minutes of the December 11th, 2018 meeting.
Is there a second?
Second.
All in favor?
Aye.
Any opposed? Motion carries. Case updates by Ms. Pamela Spicer.
Good morning, everyone. I'm here to update you on the status of the Watson North Funeral Home Cremation Center and Memorial Park, Whispering Winds Crematory, and the Thomas Henry North matter. As this board knows, this matter was set for today. However, based on motions that were filed, the matter was continued by the court because Mr. North had back surgery. My information that I received from opposing counsel was that he had back surgery, I believe, the end of November, and how that poses us a problem today was because we were in the process of scheduling depositions in December, which we were unable to set because of Mr. North's back surgery and because of the unavailability of some of the state's witnesses. The court granted the motion, and it has not been reset. I anticipate that we would like to reset it for the March funeral board meeting, but has been continued indefinitely by the administrative law judge. This is based on opposing counsel needing to notify me when Mr. North is available for depositions. Obviously, if he's under the influence of any medication, it would be not wise to depose him at that time. So I just wanted to come before the board and update you all and let you know what has happened and where we are. I have no reason to believe that this matter can't be heard in March, but it is litigation, and with litigation pending, you never know what could happen. I have updated all of the witnesses, all the state's witnesses accordingly. And as you all know, this is a very fluid situation, and there may be information that I need to bring before the board next month at the February meeting. But as it stands right now, that's the update that I have.
Thank you, Ms. Spicer. Next item is Sarah Page.
Good morning, members of the board. It's nice to see you. I know it's been some time. I came with some good news to update you on. I'm sure you all remember the hearing we had together involving Alfred Tacker and Bartlett Funeral Homes. It was kind of our marathon evening that we had a case on. In that case, this board authorized the revocation of both Alfred Tacker's funeral director license as well as a 6-month suspension of the funeral home and $8,000 penalty for each of those entities for a total of $16,000 and costs. After that case, Mr. Tacker did appeal the board's decision to Chancery Court, and I was happy to update you that the Chancellor reviewed the order from this board and heard oral arguments and upheld the board's decision on all aspects. So at this time, the matter is resolved. The board's order as it was given that day stands. There's still a potential that the respondent could appeal to the Court of Appeals. I spoke with his attorney. Right now, it doesn't look like that will likely happen, but I did want to let you know. And so on your iPad, there is a copy of the Chancellor's order for your review whenever you'd like. But at this time, there's no further action for this board to take. And I wanted to thank you all, honestly, for that very long hearing. I know I didn't warn you, and I didn't know either. And the Chancellor was very impressed with the thoroughness and professionalism of this board and notes as much in the order. So you did a fantastic job on hard facts and represented us well at the higher level courts as well. So thank you.
Thank you for what you have done, too.
Do you expect the civil penalties that were issued in that case, have they been, do we know if they've been paid?
Have not been. Mr. Gribble, correct me if I'm wrong, has that resulted in the holding of a renewal?
Well, actually, I don't think they had a conversation with us, and it was going to result in the holding of the renewal of the Bartlett Funeral Home license, so they did not apply for the renewal, and that license expired. Ms. Bohannon, was it December 31?
It was November 30th of 2018.
License for Bartlett Funeral Home is currently in an expired status, and expired November 30th, 2018. 90 days to pay the penalty, but then the court, so I don't know. Obviously, we'd look at it but they've got 90 days to renew or reinstate their license. Otherwise, then at the other point, then they would have to apply as an.
And they just received costs. We've held costs until we completed the matter. So they received that last week, and they'll have 60 days to pay the costs as well. Following that, after that's not paid, this matter, if it hasn't been paid, we will be sending it to collections. But due to the amount, it would actually go to the Attorney General's collection wing instead of to a private collection agency. So there's the potential that it could be collected at that level as well if they don't pay voluntarily in the meantime.
Thank you.
Do we have any other questions from the board members? Thank you, Ms. Page. Moving on to our legal report, Ashley Gino. Ms. Gino.
Good morning, board members. The first item we have on the legal report today is complaint number 2018-083-471 against an establishment with some disciplinary history. On November 27, 2018, a board field representative performed an inspection of the respondent establishment. At that time, the representative discovered the respondent's establishment's license was expired from September 1, 2018 through September 3, 2018. During that time period, the respondent establishment handled the disposition of the remains of 2 deceased persons. In response, respondent indicated funding was approved and made available to its administrator to renew the license in mid-August. However, the administrator suffered a family loss on August 27, 2018 and went on bereavement leave, returning to the office on September 4, 2018. It was not discovered until after the fact that the licenses had not been renewed in August. Legal would recommend a letter of warning.
Motion to approve.
Is there a second?
Second.
All in favor?
Aye.
Any opposed? Motion carries.
The next two items are on the legal report are complaint number 2018-079-881 and complaint number 2018-081-771 against the same establishment with no disciplinary history. Two rival establishments filed complaints against the respondent establishment alleging the respondent's advertisement violated Tennessee Code Annotated 625106, which provides any advertisement by a funeral director or embalmer for the sale of merchandise or services that indicates a specific price shall include an itemized listing of each and every item, procedure, or service, and shall show the price of the item. Failure to include the itemized price listing in any advertisement constitutes misrepresentation or fraud in the conduct of the business of the funeral establishment or false and misleading advertising as used in Section 625317. The advertisement in question provided two charts. The first chart compared the price of certain services and merchandise available at the respondent establishment to the prices of those items at three rival establishments. Specifically, the chart provided the following categories. 1. Basic services of the funeral director and staff. 2. Embalming. 3. Use of facilities for visitation. 4. Use of facilities for funeral service. 5. Use of staff and equipment for graveside service. 6. Transfer to the funeral home. 7. Transfer to the cemetery. 8. Service vehicle. 9. 18-gauge casket. 10. Outer burial container. 12G vault or Monticello vault. 11. Sales tax. Below the first chart, it was noted that the prices are accurate and current as of September 24, 2018, and are taken from the provider's general price lists. Prices are subject to change without notice. The second chart compared the price of the direct cremation available at the respondent establishment to the price of this service at the three rival establishments. Above this chart, it was noted that charges include direct cremation and alternative cremation container. Below the chart, it was noted that charges do not include cash advance items such as newspaper notice, death certificates, opening and closing fees, cremation permits, or sales tax. Prices are accurate and current as of September 24, 2018, and are taken from the provider's general price lists. Prices are subject to change without notice. In response to the complaints, the respondent indicated, 1. The charts appeared to correspond with the rival establishment's general price lists, and 2. The advertisement would not be used again. Legal would recommend to close.
Motion to approve.
Is there a second?
Second.
All in favor?
Aye.
Any opposed? Motion carries.
The next items on the legal report are items number 4 and number 5, which are related complaints. The first is complaint number 2018-081-221 against an establishment with some disciplinary history, and complaint number 2018-081-241 against a funeral director with no disciplinary history. On November 6, 2018, a board field representative performed an inspection of the respondent establishment. At that time, the representative discovered the respondent funeral director's license was expired from August 31, 2018 through September 24, 2018. During that time, the respondent funeral director signed 2 death certificates and 1 authorization for a cremation and disposition form. In response, the manager of the respondent establishment indicated that she was the one who made the arrangements for all three of the involved deceased person, but her new assistant placed the wrong name on the 2 death certificates at issue. She also indicated that this issue has been addressed with the assistant and remedied. She additionally indicated that she was not aware of the respondent funeral director's license lapse. The respondent funeral director also submitted a response indicating that she applied for the renewal of her license on July 30th, 2018, and thought that the process was successfully completed at that time. However, she was later informed her license had not been successfully renewed due to a $5 deficiency in the renewal payment. When she learned of this, she sent in the additional payment. Legal would recommend a letter of warning against the establishment and a letter of warning against the funeral director.
Motion to accept.
Is there a second? Second. All in favor? Aye. Any opposed? Motion carries.
The next 2 items on the report, items 6 and 7, are again related complaints. The first is complaint number 2018079951 against an establishment, and complaint number 2018080011 against a funeral director. The establishment does have some disciplinary history, and the funeral director does not. Complainant, not next of kin, filed a complaint against the respondent establishment and the respondent funeral director alleging professional misconduct. Specifically, the complainant alleged, 1, the respondent funeral director did not follow the deceased's wishes. 2, the respondent funeral director removed the deceased ashes from 2 boxes and poured the ashes into 1 bag in front of the deceased's widow. And 3, the respondent funeral director defiled the deceased body by cutting his beard before the cremation. In response to these allegations, the respondent funeral director indicated he was threatened and given competing instructions by various individuals. Specifically, 1, he was told a non-family member had power of attorney for cremation. However, the step-granddaughter of the deceased told him that the power of attorney for cremation was invalid. 2, the step-granddaughter of the deceased, a paralegal at a law office in another state, threatened to sue him if he honored the power of attorney. She purported there was a second will that was drawn up a couple days before the deceased passed. 3, the step-granddaughter requested the respondent funeral director provide her with some of the ashes, some hair, and a fingerprint from the deceased. She told the respondent funeral director that the deceased's wife, her step-grandmother, had given her the okay. 4, after the cremation, the respondent funeral director placed the remains, including bags with locks of the deceased's hair, in 2 containers. Not long after this, however, the caretaker of the deceased's wife told him none of what the step-granddaughter said was true. 5, after the conversation with the caretaker, the respondent funeral director traveled to the home of the deceased's wife to look at the deceased's will and other legal documents. He read the papers and saw where all 4 of the deceased's children were excluded in the will. There was also an indication that the individual with power of attorney was to direct the disposition of the deceased's remains. 6, the respondent funeral director stated that after reading the documents, he went to his car and provided the caretaker with the 2 containers of ashes along with the plastic bag of hair. He indicated he did not pour the ashes into 1 container. Rather, the caretaker's husband did so several days after he left. Specifically, the caretaker's husband placed the ashes in an urn and a keepsake, which the deceased's wife wears around her neck. In support of his response, the respondent funeral director provided the deceased's will, executed power of attorney, and a letter signed by 1, the deceased's wife, 2, the caretaker of the deceased's wife and her husband, and 3, a witness to the power of attorney document. The letter indicated that statements made by the complainant in her complaint were false. This letter also indicated that the signers were very satisfied with the respondent funeral director's care and concern. In an addendum to the response, the respondent funeral director additionally indicated neither the step-granddaughter nor the complainant attended the deceased's funeral. Legal's recommendation would be to close the complaint against the establishment and to also close the complaint against the funeral director.
I'll make a motion to approve.
We have a motion to approve by Mr. McKinney. Do we have a second?
Second.
We have a second by Mr. Bridges. All in favor?
Aye.
Any opposed? Motion carries.
The next item on the legal report is item number 8, complaint number 2018-078-121 against a funeral director with no disciplinary history. Complaint filed against respondent alleging unprofessional conduct. Specifically, a sibling of the deceased, not next of kin, filed a complaint with the board alleging the respondent allowed cremation of the body without first letting the family view the body and witness the start of the cremation. Complainant also alleged the respondent vocalized traumatizing and insensitive statements to the family. In response to these allegations, the respondent provided the following timeline. 1. He had preliminary discussions with the deceased's wife, next of kin, before the deceased passed and immediately upon the deceased's death. At that time, the wife made clear to him that she wanted the basic cremation package. She also made clear to him that she did not want the rest of the deceased family to be present or participate in making cremation arrangements. 2. The deceased died on Wednesday, October 24, 2018. The next morning, on Thursday, October 25, 2018, the deceased wife signed all of the necessary paperwork for a direct cremation. The cremation was then scheduled for Friday, October 26, 2018, in accordance with the establishment's standard procedures. The body was not embalmed. 3. On Thursday, October 25, 2018, the respondent and the deceased wife did discuss the possibility of family members observing the beginning of the cremation process on Friday. Notably, the wife claimed she was specific concerning instructions regarding the viewing and that she did not want anything done until family members arrived. 4. On Friday, October 26, 2018, the deceased wife called the respondent and stated that the family members would not be in town to view the cremation until Saturday, October 27, 2018. At the time of this conversation, however, the respondent was working remotely and was not aware that the cremation process had already begun as scheduled. The respondent denied making any disparaging remarks to anyone in the conversation with the family. He, however, did state that during the conversation, an unknown member of the family on the phone became upset and other unknown members of the family began to shout and threaten him. At that point, he terminated the conversation. In addition to his statements, the respondent also provided the Statement of Funeral Goods and Services contract, which was signed by the deceased wife. None of the options for viewing or visitation were selected, and the deceased wife was not charged for any viewing and/or visitation. An investigation was conducted into this matter. Recordings of the family's conversation with the respondent were provided. The family members were emotional throughout the conversation, expressing both anger and sadness. The respondent went through the timeline of events with the family members and apologized for any miscommunication. After this, the mother of the deceased blamed the respondent for not allowing her to see her son one last time. In response, the respondent told her she had ample time to see her son while he was sick. The respondent then apologized for making this statement. Notably, during this time, the mother of the deceased repeatedly called the respondent an evil and wicked person. Legal would recommend closing this complaint.
So are you saying then the funeral director did admit making those statements on the telephone?
So, in response, the funeral director denied making any disparaging remarks and stated that the family did begin to shout and threaten him, and that's when he terminated the conversation. When we investigated and we were provided with the actual recording of the conversation, the respondent did make the statement that the mother had time to see her son while he was sick. So he didn't deny making that statement in the response, he just denied making any disparaging remarks.
How was his tone?
When he said that?
Yes, based on the audio.
I think that that's subjective. I can say that that part of the recording was near the very end of what was a 20 to 30 minute conversation with a very emotional family.
I would like to see maybe a letter of warning and mention the rule that we have in place about treating the public in a respectful manner. I know sometimes we all can let our emotions get the best of us, but I think we've had some cases like this in the past where we actually issued, some civil penalties. So I would just, at least in this case, I would make a motion that we send a letter of warning and pointing out that the rule. I don't have it in front of me, but
We have a motion by Mr. McKinney. Is there a second?
Second.
We have a second by Mr. Bridges. All in favor? Aye. Any opposed? Motion carries.
The last item on the legal report today is a represent of complaint number 20180244141 against an establishment that had disciplinary history. This matter was previously presented to the board at its June 20th, 2018 meeting as follows. Complainant alleges that on September 27, 2017, respondent contacted it for services needed on 1 hearse and 4 limousines. Complainant alleges it and respondent agreed respondent would pay $1,600 upon completion of services. Complainant alleges that despite it completing services in October 2017, respondent has yet to pay complainant for those services. Respondent failed to submit a response to the allegations. The recommendation was authorization for a formal hearing, authorization of a civil penalty in an amount of $500 plus $250 for failure to respond. The board approved that recommendation. We have an update. Despite our attempt to follow up with the complainant regarding the status of payment, we have been unable to get in contact with him. Additionally, in September 2018, the ownership and name of the establishment changed. Based on this, legal's new recommendation would be to close this complaint.
was this respondent an establishment or a funeral director?
It was an establishment.
Okay. I'll make a motion to approve council's recommendation.
We have a motion by Mr. McKinney. Is there a second?
Second.
We have a second by Mr. Bridges. All in favor? Aye. Any opposed? Motion carries.
Thank you, board
Thank you.
members. That concludes the legal report.
Thank you, Ms. Gino. Now, moving on the agenda to the director's report, Mr. Robert Gribble.
Thank you, Mr. President. Board members, first we'll look at the legislative update for today's meeting. We have not received any official notification from either the Tennessee State Funeral Directors and Morticians Association or the Tennessee Funeral Directors Association of any new legislation that they intend to pursue this legislative session. The Board of License is administratively approved by the Executive Director pursuant to the Board authority for the period of December 11, 2018 through January 7, 2019. Establishments who changed the name, and I would point out that Bennett, May, and Pierce Funeral Home and Crematory in Pulaski added a crematory as well. So after they did that, they did a name change, or while they were doing that. And then 2 individuals whose license I have no closed establishments to report today, and disciplinary action report. This is a report of consent orders that have been administratively accepted and approved by the Executive Director pursuant to Board authority, and as reported on the November 2018 Regulatory Board's disciplinary were contained within that November disciplinary action report. Complaint report is for today. We have 21 complaints that are against either funeral directors or embalmers, 26 against establishments, for a total of 47 complaints. Glad to answer any questions that any board members have. If not, that would conclude my report, Mr. President.
Thank you. Do we have a motion to approve?
So move.
Second.
All in favor?
Aye.
Any opposed? Motion carries. Next item on the agenda is the approval of license applications.
Board members, you have one individual to appear before you today, Terry Lee Alexander of Nashville, Tennessee, who is seeking licensure as a funeral director. Based on the application, it appears the board may, among other pertinent statutes and rules, specifically examine the applicability of Tennessee Code Annotated 62-5-317 and making a determination as to whether the applicant meets the requirements for licensure. Mr. Alexander, if you will, please introduce yourself for the record and make whatever opening statement you'd like to make to the board.
Yes, sir. Thank you, Mr. Gribbles. My name is Terry Lee Alexander, and I am here today to get my application for funeral director's license approved. First of all, I would like to give condolences to Mr. Gribbles for the loss of his love. There was another board member that had a lost, and board, I have had some problems, issues in the past. All of those issues and problems, none are reoccurring. And people do change. I'm a changed person from the different person. Around the year of 2010, to give a little or take a little, I dedicated myself and my life to my career. I sacrificed. I gave up a lot of things, even lost my wife. I raised 4 boys on my own up until they're grown. I practiced good morals. I served my apprenticeship up under Davis and Campbell Funeral Home licensed funeral director Roscoe Davis for 1 year. And then next year, Minnie Pearl Davis. I entered into John A. Gupton College around 2010 to increase my education in the funeral industry. The funeral industry is my passion. I love it, dealing with families and people. In the funeral industry, I'm a second-generation funeral director. My father was Sanford D. Kelsey, ran Johnson, Coleman, and Kelsey Funeral Home out of Gallatin, Tennessee. Took me from 2010 to this point, as I sit here today, accomplish of all of those many years that I have put into my continuing education. Board members, I ask if you would consider granting my application for approval for funeral director's license today. Thank you.
definitely a lot to digest here. Ms. Hooper, have you had a chance to look over this file?
Good morning, Board. I have had the opportunity to review this application. This application is before you because of the criminal convictions there. And it's something that we need to discuss today and go over, particularly in light of the Fresh Start Act. There were a number of convictions in Mr. Alexander's application for licensure, and so I will take a moment to go through some of those. I will avoid discussing the failures to appear. There are two of those, but those are not the types of convictions that you would really consider under the Fresh Start Act. So the first conviction was in May of 1988, and it was for contributing to the delinquency of a minor. That appeared to be a misdemeanor. In May of 1988, it appears related to the same case, assault on a minor, and that was also a misdemeanor conviction. In April of 1996, there was a conviction for driving on a revoked license, and that was a misdemeanor. In October of 1996, there was also a conviction for driving on a revoked license. That was in October 1996, there was also a conviction for vehicle theft, which appears to be a felony. In March 2002, there was a conviction for worthless checks, and that appeared to be a misdemeanor conviction. And finally, in June of 2006, there was a conviction for possession or casual exchange of cocaine, and that appeared to be a misdemeanor as well. So pursuant to Tennessee Code Annotated 62-5-317, the Board may refuse to grant or may suspend, revoke, or refuse to renew any license granted to any person under this chapter if the applicant for or holder of the license has been convicted of a felony or crime involving moral turpitude. However, an action taken under this subdivision shall be subject to the applicable provisions of the Fresh Start Act that are compiled in Chapter 76, Part 1 of this title. Here, the applicant has a total of 7 convictions that you all need to review today, one of which appears to be a felony, and that is the one for vehicle theft. There is the question of whether the other 6 crimes involve moral turpitude, and the Board must discuss that and take a vote. Following that determination, the Board must review the Fresh Start factors for each crime subject to Tennessee Code Annotated 62-5-317 and vote on whether this conduct directly relates to the fitness of the applicant to hold the applicable license in the profession. Now, moral turpitude has been reviewed by the Tennessee Office of the Attorney General and the Tennessee Supreme Court, and based on those definitions, I have reviewed each of the crimes, and I have an opinion on whether or not it involves moral turpitude. So what we should do at this time is have the vote on whether each conviction involved moral turpitude, but before the vote, I will tell you what legal's opinion is on whether or not it does. And then once we have gone through all of the convictions except for the felony conviction, because that is a felony conviction and those are explicitly identified under the Fresh Start Act, we will then discuss any evidence of rehabilitation or treatment that the applicant may wish to discuss with you all today.
We have, forgive me for interrupting, do we have like on some of these early, like in 1988, do we know what the age of the applicant was then?
No, everything we have is in the application before you, and so we don't have any additional information. The applicant may be able to provide you all with some relevant information if you all wish to ask the applicant some questions.
Mr. Alexander, how old were you in 1988?
I believe maybe 21 or in that area.
Early 20s?
Yes, sir.
Okay.
Application contains a date of birth of 10/10/1965.
Okay.
Applicant, date of birth of 10/10/1965.
So that would have made the applicant approximately 23.
Not had a birthday on the first one, but 22.
Okay. Close enough. I'd like to go through those.
I would. So for the first crime, it was in May of 1988, contributing to the delinquency of a minor. Legal's opinion is that, yes, that crime does involve moral turpitude. So if the board could vote on whether the board agrees with that assessment.
That it does, okay.
Yes, that the crime of contributing to the delinquency of a minor involves moral turpitude. I would need a vote on that.
A roll call.
Not a roll call at this stage, just a voice vote.
Do we need a motion?
Yes, a motion, a second, and a vote.
Okay. I'll make a motion that we take the vote that we agree that Ms. Hooper's assessment is that this 1988 conviction does involve moral turpitude.
And just to clarify, there were two from 1988. This one is for contributing to the delinquency of a minor.
Yes, ma'am.
Is there a second? We have a second. Mr. Shackelford. All in favor?
Aye.
Any opposed? So the motion carries.
The next conviction, May 1988, was for assault on a minor, and legal's opinion is that, yes, that conviction also involves moral turpitude.
We need a motion for everyone, for all seven, or all six?
Yes, please.
Okay, I'll make a motion that we take the vote that we would agree with council's assessment that this does involve moral turpitude of assault, I believe.
It is assault on a minor.
Yes, okay.
So we have a motion by Mr. McKinney. Do we have a second?
Second.
We have a second by Mr. Bridges. All in favor?
Aye.
Any opposed? Motion carries for number 2.
The next conviction was April 1996, driving on a revoked license. Legal's opinion is that that is not a crime involving moral turpitude. And if the board could vote on that as well.
We have a motion.
I'll make a motion that we take the vote whether we agree with the council's recommendation that this does not involve moral turpitude.
We have a motion by Mr. McKinney. Do we have a second?
Second.
We have a second by Mr. Davis. All in favor?
Aye.
Any opposed? Motion carries. Number 3.
The next conviction was October 1996, driving on a revoked license. Legal's opinion is that it does not involve moral turpitude.
We have a motion.
I'll so move. Do I need to state that again?
Please.
That we are agreeing with council's assessment that this does not involve moral turpitude. And that was driving on a revoked license.
That's correct.
Is there a second?
Second.
We have a second by Mr. Bridges. All in favor? Aye. Any opposed? Motion carries. for number 4.
We will skip the next conviction for vehicle theft in October 1996. That does appear to be a felony, and move on to the next conviction. It was in March of 2002 for worthless checks. In legal's opinion, that is a crime involving moral turpitude.
Do we have a motion?
I make a motion that we agree with counsel's recommendation that the conviction of the worthless checks do involve moral turpitude.
Is there a second?
Second.
We have a second by Mr. Bridges. All in favor?
Aye.
Any opposed? Motion carries for number 6.
And the final conviction that we're discussing today is the conviction in June of 2006 for possession or casual exchange of cocaine. In legal's opinion, that is not a crime of moral turpitude, and so we would need a vote on that.
We have a motion.
Still looking for that one.
Trooper, could you give us more information as to how you reached that opinion?
Yes, there's case law from the Tennessee Supreme Court, and there's also a pretty detailed opinion from the Office of the Attorney General. And essentially, simple possession of drug paraphernalia does not appear to be a crime that would involve moral turpitude. Moral turpitude, one case specifically says it doesn't have a satisfactory definition, but it defines it as an act of baseness, vileness, or depravity in the private and social duties which a man owes to his fellow men or to society in general, contrary to the accepted rule or right in duty between man and man. And things such as a simple possession, driving under the influence, those types of offenses are not regarded as crimes involving moral turpitude under the law.
I make a motion that that we agree with counsel's recommendation that this conviction of simple possession is not involve moral turpitude.
We have a motion by Mr. McKinney. Do we have a second?
Second.
We have a second. by
Question, please, before you call for the vote. Does this charge, as I understand it, also include selling cocaine?
The conviction was for possession or casual exchange, and that's how it's identified on the paperwork.
You did receive $20 for the casual transfer, according to the statement of circumstances.
It appears there were some funds exchanged, but as far as the actual conviction, it started off as a charge for sale, but the actual conviction was for possession or casual exchange. So the charge started off as a charge for sale, but the actual conviction ended up being a misdemeanor for possession or casual exchange.
We have a motion by Mr. McKinney. Does it still stand with you, sir?
Yes. And I think
And the second was by Mr. Davis. Does that still stand?
Yes.
All in favor?
Aye.
Any opposed?
No. Or yes, whichever. I am opposed. So, I'm opposed.
Ms. Bohanna, we'll take a roll call.
Dennis Bridges,
No.
Robert Davis,
Yes.
Jeff Duffer,
Yes.
Clark McKinney,
Yes.
Robert Shackelford.
No.
Mr. President, we have 3 yes and 2 no in favor.
Motion carries.
Thank you, Board. So at this time, we've looked at all of the relevant crimes, and there are a total of 4 convictions at this stage of the analysis that we need to review further. The first was the May 1988 contributing to the delinquency of a minor. The second was the May 1988 assault on a minor. The third was the October 1996 vehicle theft, which is a felony. And the fourth was worthless checks. That conviction was in March 2002. So at this time, legal would direct the board to ask the applicant about any evidence any evidence of rehabilitation or treatment undertaken by the individual that might mitigate against the relationship of the crime to the occupation, profession, business, or trade. That is part of the analysis, and so we are obligated to make sure that the applicant has the opportunity to talk about any rehabilitation or treatment.
Mr. Alexander, would you like to expound on that?
Yes, sir. (1988), that particular charge, contributing to a manor, and the other in 1988, I don't understand why that it was charged against me, but at the time my attorney had said that those charges was dropped. That incident, a young lady came to my car, and she was asking for my best friend. She knew that I was his best friend, and she was asking, have I seen him? I'd never seen her before, and I said, oh yes, I know Richard. When she asked me, did I know Richard? And I said, that's my best friend. I went, she got in the car, and we went to look for Richard. And at that time, we couldn't find him. I took her to my apartment, and I left. I said, I'll be back. I will go get him. I still couldn't find him. I came back. I took her home. 2 days later, my brother came. He said, Terry, the police is looking for you. You need to go turn yourself in. I went to my father. He got his attorney, and we met downtown. I turned myself in. I went into jail as they locked me up. The little girl's uncle was there, and I was telling him and some more jailmates what had happened. And he said, do you know who I am? I said, no. He said, I'm her uncle. And he said, her mother is on the phone. She heard everything that you said. She wants to speak to you. And she told me that she had had trouble with the girl, and that she had been running away, and she had found letters stating that she had a crush on Richard. And she said she was going to tell the judge and see if I could get out. And 2 days later, I got out. And so I thought that my charges were none, but after a few years when I looked into it, the charges was there, and I couldn't get them expunged or off of my record. And so I don't understand why I understand why I got charged with it, and I can understand the delinquency of a minor. But the other charge, I just don't understand that. And to end this particular session off on this particular incident, last year during the spring, a young girl was coming in Gallatin, was coming towards a cop with a knife, and the cop shot her in Gallatin. That is the little girl. So my brother called and told me that Ella Mae's daughter got killed. I said, I seen it on the news. He said, well, I don't know what they're going to do with the little boy. I said, oh, she got children? He said, yeah. I said, how old is he? He said, he's about 30. He's the same age as T, my oldest son. And I said, well, who's it by? And he said, Richard Brownham. And my mouth was open for 2 days. And I said, that boy lied to me. But anyway, it came to me to know him that he was seeing the little girl at the time. He was my best friend, but that was my situation in this case. And any sexual assaults, I just can't see it. That wasn't me. That wasn't the case in this particular case with me. The stolen vehicle.
Mr. Alexander,
Okay, I'm sorry.
if I may, let me intervene here.
Yes.
So those first two things that you were talking about, and I think Ms. Hooper clarified it, what rehabilitation efforts were taken, or what happened once you realized that that was on your record to help you?
I did speak with ex-pastor about it maybe 10 so years, 15 years ago, when I tried to get it off my record. And he did give me somewhat counseling on the situation, how to handle it, but that was professional counseling that he gave me, and that's all of the counseling that I've had towards that issue.
Was that one session, or was that several sessions? And do we obviously we don't have any documentation that rehabilitation process occurred.
Right. Okay. Yeah, that was one session. Yes, sir.
One session.
Yes, sir.
Okay.
Alexander, because of that conviction, are you now considered a sex offender? Are you categorized as a sex offender?
No, I'm not. I am able to vote, and I've been blessed before that law came into effect.
Do you have any more questions from the board in regards to the first two items that he just discussed?
I have one from Ms. Hooper. The contributing to the delinquency of a minor and the assault on a minor, is that, just to clarify, is that the same case?
Appears to be the same case. It appears both of those convictions arose out of the same set of facts.
Alexander, you didn't address the issues about assault on a minor.
That is a charge that, again, why I say I don't understand. I don't see where that comes in to play. Assault on a minor, where was the assault? Where was the assault? How was she assaulted? All I can understand contributing. She was a minor by her and helping her find my best friend. But assault, I don't understand. I don't know how to answer that, because on paper it say it exists, but it never existed. There was no any type of violent situation. The mother even spoke with me and said that she know that I'm pretty much telling the truth, that she found letters in the girl's room. She had ran away before, and that she had a crush on Mr. Branham, and I was helping her find him. So assault, I don't understand how I could answer that. And if, when you ask me, explain the assault on her, if you can give me an example, maybe I can example, but I don't understand. I understand the question, but I don't see where it applies to me. That never was an assault, but I see that it's on paper. And that's why I say I thought the charges was redone and dropped.
And I would have to advise the board to kind of refrain from any hypotheticals and to not get too much into the facts of each of these convictions. Really, right now, we're, seeking information regarding rehabilitation or treatment, because that's one of the things that you all have to weigh under this fresh start analysis. And so that's what I would steer the discussion towards with Mr. Alexander, so that we can move further along in this process.
Any other questions from the board members in regards to the first two items, particularly with the rehabilitation or the treatment of? Okay, Mr. Alexander, then let's move over to item number 3 and 4. If you want to do 3 first, that's fine.
Okay, which one was 3?
And 3 was the vehicle theft, and 4 was the worthless checks.
Number 3, I purchased a vehicle. I was married at the time. My wife and I was going through problems. The car was in my name. Her parents had gave her a car, and the car had threw a rod. An incident came up to where I told her, if this happened again, I'm going to have to leave. If your parents come in here and try and tell us or start fussing at me like I'm a child, I'm leaving. It happened again. That Sunday, I left. I took my car and left. And her parents reported that I stole her car. She didn't report it. Her parents reported it. And so that was my car in my name. I purchased the car. I bought the car.
So if there's nothing further from Mr. Alexander on that conviction as far as rehabilitation or treatment, we would move on to the worthless checks. And Mr. Alexander, you may discuss that conviction and any rehabilitation or treatment.
On the worthless checks, my second wife, I had a lot of copies of her handwriting, of her forging my name. I had a investigator here in Nashville that was helping me to locate her on them checks. And I think the bank had been paid off, but I would take credit for some of those checks, but the balance of those checks was written on me, and it was over $2,000 that was written on me that I did not write.
So again, Mr. Alexander, is there any facts of rehabilitation or treatments in regards to these 4 items that we've talked about?
No, on the checks, no, all but the pastor that I spoke with.
That was in regards to the first 2
Yes, sir.
situations,
Mm-hmm.
but nothing in regards to 3 and 4?
No.
Was everybody eventually made whole on these checks? Did you pay all of them?
Yes,
off
sir.
finally?
Yes, the checks are paid.
Ms. Hooper, is it permissible for me to ask a question pertaining to the probation special conditions that are listed on page 22 regarding the worthless checks?
Yes, Mr. Shackelford, please proceed.
Note there under probation special conditions that this case was apparently transferred to a mental health court. Can you give any detail about that, either you or Mr. Alexander, as to what the significance of that would be and how that might apply in our discussions?
I'm not sure what the basis was for transferring it to the mental health court, but I would think it would be appropriate to ask Mr. Alexander if he's aware of the circumstances.
Alexander, can you address that question, or do I need to restate the question for you?
No, sir. I can address it. Thank you. I had gotten in a depressed stage, and at that time when my checks and things, when all of this was happening, when I think I had somehow or another it got into court and it transferred over to mental health co-op because I was being represented by them, and they was dealing with me, helping me with the checks, and that's along the time when my wife, when she had left, and they counseled me on helping me deal with the checks, and I had some with Kroger's, and some I didn't not have to pay, and the others I did pay. And so pretty much how Mental Health Co-op got involved, I think I had gotten pulled over, and it was a warrant for the checks or something or not, I'm believing. And then that's when mental health got involved, when I was incarcerated.
I'm not sure I understand who they is in that explanation. Were you involved with some type of a mental health agency at that time that was providing counseling and assistance to you? You mentioned that you were in a depressed state at that time, so were you undergoing treatments or counseling at that time with a mental health agency?
Yes, that's correct.
Okay. About how long a period of time were you involved in that program?
Maybe a year. Mm-hmm. You're welcome. If I may say, it was 2 years, because I had counseling with my family also, so it was 2 years.
So at this time, I just want to clarify for the record, Mr. Alexander, have you had the opportunity to proffer any evidence of rehabilitation or treatment for these 4 convictions?
And the 4th conviction.
That was the worthless checks that you just discussed.
Somewhat with, at the time, mental health, and prior to that, I've had a checking account for I've never had a check to bounce. My account have never closed. I manage my monies pretty well, what little I have. And checks, I don't write checks to someone and the money is not there. I've never bounced checks since I had departed from my wife. Never. Not same a checking account.
Alexander, did you enter that counseling program voluntarily, or were you mandated by the court to enter the program?
I was mandated by the court.
Seeing that we have analyzed this portion under the Fresh Start Act, I'll let the record reflect we've looked at this factor. I'll also state for the record that as far as any applicable federal laws regarding an individual's participation in the occupation, profession, business, or trade, I'm not familiar with any federal laws that would be relevant to the Fresh Start analysis today for any of the 4 crimes listed. And so for the record, there is nothing there from legal for the board to analyze. So at this time, we will move into what will primarily be the board's discussion of how these 4 crimes relate to this profession. And there are 2 specific questions that have to be analyzed. And so for each conviction, I will just state for the record the nature and seriousness of the crime, the length of time, and then I will ask the question, and then the board will discuss that question amongst itself until we go through all 4 of those. Any questions? Okay. So the first crime of which the applicant was convicted was contributing to the delinquency of a minor, and that was committed in 1988. And so the length of time since commission has been 30 years. And so the factor that the board should analyze at this time is the relationship between the nature of the crime and the purposes of regulating the occupation, profession, business, or trade for which the license is bought. Any questions there? So the board would be looking at the relationship between that crime contributing to the delinquency of a minor and the purpose of regulating this profession of funeral directing, in other words.
Excuse me.
Have any discussions in regards to this number 1?
And I'll just state the question before the board. Again, you all are looking at the relationship between the nature of the crime contributing to the delinquency of a minor and the purposes of regulating the profession of funeral directing, and discussing that amongst yourselves as a board as we analyze that particular conviction. Maybe if I rephrase the question in a way that may get you all kind of started on the discussion, how relevant is that conviction perhaps to the profession of funeral directing? And to that extent, what is the board's position?
I don't know that it's, if it's directly related or not, but all of these that we've been over that we agreed involved moral turpitude. That is one of the things that we look at before issuing a license. I'm not sure exactly what kind of answer counsel's looking for, but I mean, I don't know if it's a direct relation or if it's indirectly, so to speak.
I would just say, for the record, that one of the major purposes of, regulating this profession is protecting the public. So maybe thinking about these convictions in those terms, how the nature of the crime relates to that, maybe that'll help you all as you analyze and try to work through these convictions and determine how they relate to the profession.
This particular conviction, we could refer to as an isolated incident. It does not appear to be representative of a pattern of this type of behavior, but there are other convictions that we have addressed that fall along the same lines, involving moral turpitude and not having any more facts or evidence before us than these brief summaries of the individual circumstances. If nothing else, it tends to indicate, if there is a pattern there, it is a pattern of poor judgment, perhaps as much as anything, and my objective opinion on my part, but if there is a pattern here, it appears to be a pattern of poor judgment and making decisions that at the time were not prudent. So I guess that is my biggest concern as we discuss this matter, is pattern of poor decision making or poor judgment in varying circumstances.
I have to say that I don't feel like there's any evidence really of any rehabilitation. One conversation with a minister is hardly something that's going to put you on the right path to do things. And further to Mr. Shackford's point, a series of bad judgments occurred after that, and I just don't feel like that there's any or enough evidence here to support that there are any steps for rehabilitation in this.
Thank you. So the next part of this analysis for this particular crime, contributing to the delinquency of a minor, the board is looking at the relationship between that crime and the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of a funeral director. And so that's the next topic for you all to discuss as you analyze this particular conviction of contributing to the delinquency of a minor. Again, I'll repeat, that is the relationship between the crime and the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of a funeral director.
there again, I guess it goes to Mr. Shackelford's point about judgment. Seems like there's a series of these. If it was just one thing in 1988, I think that had a, if everything had been, if you'd had a clean record from 1988 up until now, I don't think we would be that concerned. But all of these together are concerning.
Can I speak? I understand that, and from 1988 up until now, these are 88, then 96. Looking at 30 years. Of 13 years. Haven't had any run-ins with any law, any problems, troubles with anything. And I would think if I knew that this issue was going to come up, I would go and try and had got orderly help for these things, but help wasn't needed. It wasn't a cause for help or counseling. The 88 deal, misjudgment. I agree. But if someone tell you that they are, and then at 21, 22 years old, you're having a friend, and people do change. People do change. I grew up in the funeral home. I don't hang out. I read a lot. I try to stay up on the funeral laws for years. I spent a lot of money with my, like I say, sacrifices and dedication. Now, and these charges, as I say, I can't understand the 1988. I can't understand why would I need counseling. And maybe I do. Maybe I'm just not seeing it because I feel like I deserve my license. Maybe that's the reason I'm not seeing that. And vehicle, the checks. Those are things that I couldn't help. I couldn't prevent. Someone took my checks and actually wrote checks $200-300 to pay someone else's light bill and gave it to him the cash. Having fun with that. And when I found out my money is missing, I'm highly upset. And yes, I went to counseling because of that, to mental health, because of the frustration and the stress.
And I'm sorry to interrupt, but it is important that we go crime by crime and make a determination as to whether it relates to the fitness to hold the license individually. And so we were initially discussing the delinquency of a minor, and you all were going through those factors. And so the board will need to make a determination of whether that conduct contributing to the delinquency of a minor relates to the fitness of Mr. Alexander to hold the applicable license in the profession. And that's just another step in this process. So again, that question is whether the conduct contributing to the delinquency of a minor relates to the fitness of the applicant to hold the applicable license in this profession. And that is in consideration of all the factors, when it took place, the crime itself, how it relates, which you all discussed briefly, and the evidence of rehabilitation or treatment. So you're looking at everything we discussed for that particular conviction and making a determination of whether or not it relates to the fitness of Mr. Alexander to hold the license. You're not voting to grant or deny at this time, only whether it relates.
So, Ms. Hooper, are you recommending that we take a vote based on that statement?
Yes, I'd recommend that you all vote on whether that particular conduct, in consideration of what it was contributing to the delinquency of a minor when it occurred, 1988, the factors that you all discussed as far as how it relates to this profession and the capacity and fitness to perform the duties of a funeral director, and his evidence of rehabilitation or treatment on that particular conviction. And you're looking at all that as you determine what your vote is on how it relates to his fitness to hold a license, whether it does or whether it does not. And so we would need a motion, a second, and a vote.
You need it on each one individually or all together?
This would need to be on each one individually because each conviction should relate to holding a funeral director's license. Now, when you all make the final decision, you all would be able to look at it holistically at that point and make a determination.
Just so that Mr. Alexander understands, we're going through this piecemeal because of this new law that's been passed. We're just not singling you out. I mean, this is just a process that we're having to go through today. And this is on the first one?
Yes, this is on the first one, contributing to the delinquency of a minor, because we have discussed all the factors under it at this point, and so now the next step is to vote on that particular conviction. And vote on whether it relates to the fitness of Mr. Alexander to hold a funeral director's license.
Either it does or it does not.
Yes,
And
in
that
light of all the factors.
All the factors, and
that we've
that's the
discussed.
motion itself. Either it does or it doesn't.
Yes.
Okay. Anybody have a motion on this one?
I'll make a comment that we've been through several of these before, and then we voted to affirm that several of these did involve moral turpitude. So why would they not? I guess I'm having a hard time understand. Why would each one of them not have to do with the fitness to hold a license?
Because part of the law is that you all have to look at all the factors, and so that includes what the conviction was for, when the conviction took place, and how it directly relates to that profession. So even though a conviction may involve moral turpitude, the board may determine based on the amount of time that's passed or the conviction and how it really relates to what a particular profession does, that it does not it is not such that it relates to the fitness to hold the license. So it's a different question. It's not automatic that because a conviction involves moral turpitude that it relates to the fitness of someone to hold a license. So that's an additional step of the analysis.
So we could say, since it's been 30 years ago, I think it applies in this case.
That could definitely be the board's position, but that's only because the board has looked at and analyzed all the factors and is making that decision considering all the factors we've discussed for that particular conviction.
The motion is directly at Mr. Alexander in regards to how this relates to him.
Yes, it's for this particular applicant. The board isn't making a broad decision that would apply to everyone. In other words, these are on a case-by-case basis. However, I would urge the board to be mindful that it does not want to handle any of these in a way that's considered arbitrary or capricious. And so the board does need to keep in mind that there should be some consistency over time as the board looks at these.
So to quote one of our former counsel, each tub has to sit on its own bottom.
Do you think they realize they consider that?
I think they understand it's the whole picture. So just to be clear, the difference at this step is you're looking at more than just the conviction. You're looking at all the other factors and determining based on all the other factors whether that would relate to the fitness of Mr. Alexander to hold a license as a funeral director. And you're voting on that individually per conviction. And right now we've only gone through the factors for contributing to the delinquency of a minor. And so that's the one in particular we're discussing.
Just, I guess, an observation born out of frustration for me, perhaps, but so difficult to analyze a situation like this when you talk about all the factors, and I understand those are the factors that we have before us today. I get that. I understand that, but there are so many pieces of the puzzle that are missing that we don't have access to that make it very difficult for us to ascertain how we should handle a matter like this. In my mind, my logical thought tells me that you're not charged with contributing to the delinquency of a minor just because you gave somebody a ride in your car that was underage. You're not charged with assault on a minor just because you gave somebody a ride in your car or because you left somebody in your apartment while you went to look for somebody else. But again, I don't have those facts to address those questions in my mind before me, and I guess that's maybe off limits as far as our discussion is concerned today, but it makes it very frustrating to try to resolve these issues one at a time when basically, they're all different types of cases. We've got, 6 different convictions that we're addressing today?
It's 4. Contributing to the delinquency of a minor, assault on a minor, vehicle theft, and worthless checks.
So the cocaine situation is not involved in this then? So.
That's not involved because that does not involve moral turpitude.
So we're just addressing the issues of moral turpitude. Okay.
I'd like to, in order to ask Mr. Alexander a question in relation to the vehicle theft. You stated that you owned the vehicle.
That is correct. I purchased the vehicle.
Were you able to produce the title in court? Proof that you owned the vehicle?
Yes, I did, but it was something as she was the parents did it, and then there's another thing that is just not right. I'm still understanding under the understanding of how can I be charged with vehicle theft with my own car, but her parents filed the warrant. But yes, sir, it was my own vehicle. I had the title clear in my name. I paid $600 for the vehicle.
Able to produce the title?
No, here with the records here, no, I have no clue where the title would be. It's been over 20 years, 25 years.
I think Mr. Davis's question may be, were you able to produce the title at the time
Yes, sir. Yes, sir.
was tried? You stated that you took a tag off of another car to put on that car before you left with it. What was your reasoning there? Was that had the car not been tagged, or were you trying to do that to avoid being stopped?
The car, I've only had the car 3 days, and on a Friday, my wife the parents came in and did what they did, and I was upset. Saturday, I went and got tags, and Sunday I left, and I hadn't been back to Gallatin. That incident, court costs, taxes have been paid. I dealt with that. I knew that that was wrong for me, but that was then. I'm a different person now. And 10 seconds on the child thing, that is the truth, how it went. That's the deposition that I gave in the courts when they brought me in. That's the truth. And I don't understand how I got them charged when they were supposed to have been.
So based on Ms. Hooper's recommendation, I think the board is back to only number 1, which is the contributing to the delinquency of a minor, and a motion is needed, I guess, either it does or does not relate to the fitness of the applicant to hold a license. Is that correct?
That's correct, Mr. Duffer.
Board members, any board members have any questions in regards to number 1? Have a motion one way or the other?
I make a motion that it does affect the ability.
It does relate to the fitness of the applicant to hold a license?
Yes.
Is that your motion?
That's my motion.
We have a motion on the table from Mr. Bridges. Do we have a second?
Second.
We have a second by Mr. Shackelford. All in favor?
Aye.
Aye. Any opposed? Motion carries for number 1. Same process for number 2. Is that correct, Ms. Hooper?
For number 2, the board has not yet discussed the assault on a minor and essentially how that crime relates to your purpose as a board in regulating this profession, as well as how it relates to Mr. Alexander's ability, capacity, and fitness to perform his required duties were he to be licensed as a funeral director. And so the board would need to discuss those factors before moving on to vote.
Correct. Same process as we did it with number 1.
Yes, Mr. Duffer, that's correct.
Okay. Understood. Any questions? Any comments?
To me, it's just the same circumstance, just. I don't see how we could differentiate between the two. How that we could come to a different conclusion.
And you all may have the same conclusion for every one, but it's important to state the reasons on the record so that we're able to review this and ascertain what the board's reasoning was at a later date, potentially.
Due to the fact that there was a conviction regarding the charge of assault on a minor, and really that is all we have before us, is the fact that there was a conviction on that charge, then I make the motion that it does have a bearing on his ability.
Second.
So we have a motion by Mr. Shackelford, and we have a second by Mr. Bridges. All in favor? Aye. Any opposed? Motion carries for number 2, the assault on the minor. We'll move to number 3, go through the same process and have the questions, discussions. And that is the theft of the vehicle.
Yes, and that was conviction from 1996. And so the board is looking at, again, the questions of how that crime relates to the purpose of you all regulating the profession, and how that crime relates to the ability, capacity, and fitness of Mr. Alexander to perform the duties and discharge the responsibilities of the profession.
I personally think that the vehicle theft and the conviction of that crime is a serious situation. Certainly, it affects our profession and our industry as a whole.
And that has occurred since numbers 1 and 2 also. Hasn't been as long as the first 2.
Alexander had stated that 1988 it was 30 years, 1996 were 20 years, and then the most recent one's 12 to 13 years, and it goes back to that same pattern. That's the problem I still have.
Make the motion that this does affect his ability to practice as a funeral director.
We have a motion on the table for Mr. Bridges. Do we have a second?
Second.
We have a second from Mr. McKinney. All in favor?
Aye.
Any opposed? Motion carries for number 3, the vehicle theft. We'll move over to number 4, which involves the worthless checks, and we'll have the discussion in the same process. Is that correct, Ms. Hooper?
Yes, that's correct.
Thank you.
Alexander, just to be clear, in your statement of circumstances, you credit your then spouse with writing 75% of the worthless checks, and then you take apparent responsibility for the remaining 25%. Is that an accurate assessment of what your intent was?
Ms. Hooper, what year was that?
That was in 2002.
Thank you.
I would say that this does. We even have specific rules on the books about funeral homes, or I don't know if it says establishments or licensees paying their financial obligations. So I would say that this one would also apply. And I'll make that in the form of a motion.
We have a motion by Mr. McKinney that this does relate to the fitness of the applicant to hold a license. Do we have a second?
Second.
We have a second by Mr. Bridges. All in favor? Aye. Any opposed? Motion carries for number 4 in regards to the worthless checks.
Thank you, Chairman Dupper. So let the record reflect the board has determined that all 4 of the convictions at issue relate to the fitness to hold the license. So at this time, I think it would be appropriate to open the floor for the board to hear from any other individuals that Mr. Alexander may wish to speak, or for the board to ask any other questions of Mr. Alexander that it wishes to ask before voting on the actual application itself.
Thank you. Mr. Alexander, do you have anyone here that's with you today that you would like to come and speak on your behalf?
Yes, sir, Mr.
Good morning to the board.
Good morning.
My name is Thomas Wilson. I was asked to come here this morning by Mr. Alexander on his behalf to meet with. I'd like to start, I guess, by giving a little history. I met Mr. Alexander approximately 11 to 12 years ago. He came to a particular church that I had attended for years, and he came there seeking membership, and shortly thereafter, he sought to become a member of the Deacons Board. To move forward, 3 or 4 years, he was addressed by the church, and he did become a member of the Deacon Board and served there continuously for about 6 years. And he and I have since joined a new church, and Mr. Alexander is a member of the Deacon Board. I was impressed by Mr. Alexander shortly after knowing him by the manner in which he raised his boys. He had 3 boys that attended that church, and they were all very mannerable young men. And shortly thereafter, I met 2 more. They all served in different capacities there. Some of them played with the choir. Others were on the usher board. And I began to know him and develop a friendship with him as we worked together, mostly through the church. In my dealings with Mr. Alexander, I found that he really does love his business, and he enjoys the service that he provides to the society. As far as the issues here at the board this morning, there are a few things that I would like to say. First of all, I was not aware of all of the convictions as they have been outlined this morning, but he had made me aware of 2 of them. First of all, I'd like to say, as far as the delinquency of the minor and the assault charges, I noticed that there were convictions, but I don't hear anything about sentences. I also am very well aware of the judicial process and how they sometimes refer to a system of cleaning up the board, meaning you go to a higher charge, especially if you're seeking an office in a particular county. And that can end up in a conviction where a minor charge could have actually been what the exact circumstance was. Now, what Mr. Alexander hasn't done this morning, he hasn't dressed himself legally to be able to come here to refute those by bringing you board members any additional information as to why he did not serve any time under those convictions. So he hasn't given you any written material that you can see and be able to move forward with as to verify what he's telling you. What you have to rely on now is that he said that he picked up the young lady, took her to the apartment, there was no drugs, and he said there was no violence. But this you are hearing him say. As for the other part, the courts did see that they and went forward and made a conviction. So is he telling the truth? Is he not telling the truth? Okay. On the incident with the vehicle, well, I can understand that also, because once he was married, that car, I think, becomes, I'm not a lawyer, but I think it may have become what they sometimes call community property. So if he took his own car and left, yes, he could be charged with theft of his own vehicle. But in fact, with Mr. Alexander being a young man and not knowing any more about the law than that, and also maybe having been angry, then he didn't seek to ever redress that, just as he did not with the checks. Mr. Alexander has been rehabilitated. I heard what he said, and I understand what he didn't say, but he's been rehabilitated in that he's lived a rehabilitated lifestyle. First of all, we learn as we grow and as we age, what you do if you're involved in a situation, you move from that situation and don't allow it to happen anymore. That's what he did on all of the cases that have appeared before you guys. He has moved away from that. Yes, he has a rehabilitated lifestyle in that he seeks more religious guidance now. He said had counseling, one session with one minister. But Mr. Alexander's had many counseling sections as he's talked this over with the current minister we have now, and as he shared that with any of his peers. And he said he would have done things differently. Did he ever seek going back to the general counsel or through someone else who could have better educated him, which is one factor that he needed a lot of help on being better educated. But being a person that was at his age and his financial limitations and not having any more knowledge about the law, the result is what you see and what you have here today. This is an honest man. He has told you truth, maybe more truth than some people would have said that he should have told you. But I understand that he did tell you that because he wants to be completely open. And I believe in being open, you have to show some signs of being honest. If anyone wants to say that a man who comes before you and can be as open as this man is and he's not honest, I see some frailty in that judgment. Now, Mr. Alexander is also rehabilitated in the way that he assists the public now. He hasn't revealed to you all the ways in which he has clients and other persons who come to him, in which he assists them in being able to seek that service at a decreased rate to where he can help that family while they're in judgment, while they're in bereavement there, and they're judging his business against the prices on other business. He makes it possible for them to be able to put their, as we say, put their people away in dignity, but sometimes at a lower cost just by telling them everything in which they can be able to purchase caskets and other things. Yes, it's been years since all of these things came about, but you're not dealing with a community felon or someone who's seeking to run or dissuade the judicial system or to go around the feeling of reasons and of the board here. You're dealing with a man who did not understand any way in which to dress to come here to convince you this morning of where he particularly is, and he has been changed. And I don't know if the board, how you might look at it today, but if he had some time limit to go and to seek better evidence and investigate these things himself and bring you back evidence of what did and did not happen and what his play was on each one of those convictions, then you might have a little bit more evidence and help you to reach maybe a different judgment with the person. I see him 2 or 3 times a week. You see him here as the board today. He's a credit to society and with the business that he's tried to run and help the Miss Davis out in these last few years. I know him to be a credible person. I know him to be a man who gets up at night, goes out, picks up, comes back, and still present to raise his boys and do the best he can. He's an admirable man, and he's done good with his boys, and he's seeking this license. And if you would give him some leeway to be able to produce some evidence of what he did do and did not do, I think it would be a credit to him and what his position is now. And that's all I guess I have to say this morning.
Thank you, Mr. Wilson. I've got a couple of questions. You had mentioned that he'd only discussed only 2 things of what we talked about today.
Yes.
And those two were what?
He talked to me about the particular conviction that he had with the cocaine and how that was there. And he's mentioned a lot of times how he didn't know how that ever happened, because he said he's never been involved with drugs and there was no drugs present. And I had, as a matter of fact, I had told him that he needed to seek to have that removed from his, but this has been shortly, I guess, in the past month. I told him he needed to seek to have that removed from his conviction record. And the other one that he told me about was the car. We were talking about cars one day and incidences, and he said, I've been convicted of stealing my own car. Would you believe that? I said, well, it can happen. If you were married and you left with a car, yeah, it can happen. He morally didn't see, I guess, him doing anything wrong, just to put it in a vernacular.
Yes, sir. The other item, you had mentioned that he had sought rehabilitation with the pastor there, I guess, at the current church you're at. Is that something that pastor told you, or is this hearsay from Mr. Alexander?
This is from his continued devoted lifestyle. I'm looking at rehabilitation as to how a person matures and their lifestyle. And what I'm saying about Mr. Alexander in that is that rather than being counseled on a particular incident, if we take into effect that Mr. Alexander did not see himself as committing a crime, then he can't seek rehabilitation. The only thing he can look at is what his position is. And if you are any of us in any particular position where we morally don't feel as though we've committed a crime, then what you do is you just change. You move away so that incident can't happen again. And that's what he's assured me he has done. And that's what I see in his lifestyle.
Thank you.
Yes.
Mr. Alexander, you are currently employed at Davis Campbell Funeral Home here in Nashville?
Yes, sir.
Okay. How long have you been with that firm?
Say 6, 7, 8 years.
What are your duties with Davis Campbell presently?
I am a licensed apprentice for funeral director license, and I perform the duties as a apprentice funeral director, guided by the licensed funeral director, Mrs. Davis.
Did you ever serve any time for these convictions?
Oh. So maybe like 3 or 4 days, time for the court.
So it was probation.
Yes, sir.
Okay.
Mr. Alexander, do you have anyone else that is here that would speak on your behalf? Is Ms. Davis here, or any?
No, she's not, and no, and Mr. Hatch, he had something to do, so he had to leave. Thank you.
Just Hooper, for the record, the last conviction was in '02, is that correct?
Yes, the last one we're looking at today is in '02, and that was a misdemeanor conviction for worthless checks.
I was looking on one of these forms, and I'm not... I'm just looking at some dates on this record. There's a date of 1/26/17, a garnishment served and fees assessed. Is that just for court costs that hadn't been paid, or what? Do we know what that was for?
Can you by any chance direct me to the page?
Page 2 of 4.
Page 2.
It's 29 of 42 on there.
So what that appears to be, and that one deals with the one for possession that we're not considering today, but what that appears to be is where there were probably costs involved that were assessed, and they got some kind of garnishment order to go ahead and collect those costs. But that relates, from the document I'm looking at, that relates to the conviction for possession or casual exchange, and that's one we're not looking at today.
Okay, all right. So have all your court costs and everything been paid up, and you're clear with the court?
Yes, sir, I am, all but that Robinson and Reagan, the one that you're looking at, and I have a son that got in trouble, and I'm paying his court cost.
Okay.
I have to pay it.
Okay, but nothing regarding the other convictions that we
No,
talked
sir,
about today?
that they're all paid.
Okay.
Feel the need to note that, in my opinion, there have been some statements that we've heard today that have been contradictory. One example that I would give is in regard to the cocaine charge, and I know that's not one of the 4 that we are considering, but it is an example of what I interpret to be a contradictory statement. The statement was made that there were no drugs present, but that appears to be in direct conflict with the statement of circumstances that we have in our packet, where Mr. Alexander states that they were supposed to be meeting someone, and I told them I would rather take it to them around the block myself than to meet at my house. So I did meet them. I was caught when they gave me the $20 at once. So that appears to indicate was something present that was exchanged. It just concerns me that we're hearing some contradictory statements today.
So the board has completed the fresh start analysis and it's heard from the applicant and the applicant's guest. And at this time, the board is looking at how it wishes to decide on this application and whether the board wishes to approve or deny this application. And so I know the board, may wish to deliberate or ask further questions, and the floor is certainly open for you to do that, but that's where we are in terms of this entire analysis.
Alexander, how much time do you have remaining on your apprenticeship?
Apprentice is complete, and I do have a I have completed my apprentice. Yes.
Would it be correct to say that since his apprenticeship has been completed, if and or until he is licensed, he can only function in the capacity of an unlicensed assistant?
Looked at his registration a minute ago, and I've moved from my phone to where I looked at it, but it expires sometime, I think it's in October of 2019. That would be a determination legal would make. I mean, it's we have documents saying that he has completed have certification of completion of apprenticeship, that he's completed the time required, but then he has a registration certificate that doesn't expire until later this year. How that would, he's as far as his apprenticeship, he's met the requirements he needs to be before you today to seek licensure as a funeral director.
Were you employed before Davis Campbell?
I was been disabled, and so I just do.
Okay. There wasn't another funeral home that you had worked at, or?
Yes. Now I had started out at House of White. No longer exists. That's long ago, and then Strutter and White, and then Davis and Campbell.
Ms. Hooper, I have a question. So if Mr. Alexander was not granted his license today, what would his next steps or the recommendation be as far as the writ of treatment? Is that something he could seek and then come back again in front of the board, or what's the council's recommendation to that piece?
The board could certainly give Mr. Alexander some guidance if the board wishes to deny the application, but one of the requirements of the Fresh Start Act is that if someone is denied, that the board provide them with a date that they can reapply. So essentially providing a date that the applicant could submit a new application and have the board consider it. And so I think both of those are options for the board to identify a new date that the applicant could reapply and or give guidance to the applicant as far as its basis for denying the application, which might help the applicant prepare if the applicant wishes to submit a new application at a later date. Those things would only come into play if the board wishes to deny. The board could also vote to approve Mr. Alexander's application as well.
Is that? Yes, sir. I want to be sure that I have your name correct. Forgive me for that. Mr. Wilson has suggested in his remarks today that the board could consider giving Mr. Alexander additional time to furnish more information pertinent to these convictions that might or might not influence the board's decision one way or another. Is that something that the board would even want to consider today?
Did you say his application was good until, or you didn't?
Application expires in 90 days from the time it's first received.
Okay, okay.
And
When
it
was
was
it first
received
received?
December 7, I think. I remember seeing that. Ms. Bohannon, you have that date. Is received December 6. So the application will expire 90 days from December the 6th, whatever that is.
Roughly February the 6th?
March the 6th.
Okay.
March, 6 or 7. February has 28 days. So somewhere prior to March, somewhere prior to probably the March board meeting. March board meeting.
12th.
It would expire prior to that.
Mr. Alexander, you have not had any run-ins with law enforcement since 2002? Is that correct?
I think 2006, but prior to that, none.
What was the 2006?
Yes, that was.
Okay.
Because he had mentioned 12 to 13 years.
Okay. And that's been 12 years, I guess, yeah.
Alexander, another question, please, sir. You had mentioned you didn't know these record. At what point did you know for sure that they were on there and that it would affect, and why you're here today?
Repeat that question, please. I missed the first part.
When did you realize that this history was going to affect your licenses, or obtaining them?
Something I had pulled my records, and I seen those records, and I was like, wow, I got to take a registration date came. I thought I had to have all of my and when I got all my records. I took them to Miss Donna, and she said, "You're gonna have to have these for the board. Just hold them."
That was in, I know it's in here and amongst all these documents, but what year was that?
I'd say 2010.
8 years, almost 9 years ago.
Yes, sir. Say that then maybe 2 years later, that was just the records that I could think of. Then I applied for some insurance producer's license, and then that's when I found out, when I looked and seen all of the other.
In the microphone, sir.
Yeah, and when I filed for a producer license insurance,
Yes, sir.
that's when I got the response back, and then those charges, all of them was listed on the form of why. And so,
You knew at that time it was getting serious.
yes, I knew it was serious.
Okay.
And I was already in school. Mhm.
Alexander, have you ever made an attempt to have any of these convictions expunged from your record, or
Child, okay, the child's case, it can't be. It's because the judge won't hear that again, and the others, I may have to look into again because I don't quite remember how they all went. But I know I tried the child's case. Mm-hmm.
Alexander, I still am struggling. I know that first incident happened 30 years ago, but as I've heard today, pattern of activity here with these issues from 98 all the way up through 2006. I do believe that people can change, but I don't think, personally in my opinion, that we have enough evidence to show rehabilitated, you've seeked treatments, counseling to that extent to know that, or make me feel as though I could vote in favor of this.
So, in other words, that I've been rehabilitated, and these are reoccurring incidents.
I don't have anything other than what you've said today, which has been a short period of time, and these documents, which are a lot of documents, but I don't see anything. And yes, the pattern of these cases are very concerning.
So, that a person can change, what must I do? I'm one of those that live on Section A. I went to the director. I want to be one of the ones to reach out and speak to people and tell them that this program is not to live on for life, but to better yourself and change. It's to help the people. That's where I'm going. That's where I'm headed. And that's just another example of the moral character that I am and that I want to be for the public and for this profession. And an example of how I am, the type of person I am.
Mr. Alexander, I clearly understand what you just said. I believe that you can. I believe that you are capable of doing that. I just don't have in front of me the evidence to where I feel comfortable to grant those licenses today. Not to say that you're not able to go out and get some sort of rehabilitation or treatment or something to present to the board in your application to be a little more convincing.
So let me ask again, what should I do? What suggestions, and I don't know if you're able to give suggestions, but in order to come back before the board to make this in order?
Cooper, do you have any recommendations from a legal standpoint?
I think this would really deal with kind of what the board would need to see that it didn't see today. And I would caution the board not to suggest that under certain circumstances it would approve a license in the future because, there are so many variables. For example, we're not sure who will be on the board if and or when Mr. Alexander's application is denied and he reapplies. And so things like that have a bearing on what could happen in the future. And so I think the board is free to talk about some things that maybe would have helped convince this board today to grant the application if the board wishes to deny it. But I'd caution the board not to make any commitments as far as what may happen in the future if the board were to deny this application today and were to be looking at a new application at a later date.
I might just make a few comments to Mr. Alexander and the other board members. Of course, don't take anything we say or do personally. We're just charged with an enormous responsibility here, and we only have to make our judgment on the information that we've got before us, and we've got almost a book's worth of stuff here on our iPad, and we get to make judgments about that. And then, of course, your testimony and Mr. Wilson's, and I appreciate Mr. Wilson's comments on your behalf, and I'm all for second chances and forgiveness, however you want to put it. But for me, I guess I'm like Mr. Duffer. Through the years, there's been such a pattern of mistakes and maybe poor judgment. And I know the last thing, was considered a minor thing in 2006. That's been 12 years ago. But from my own personal standpoint, if there had been more Mr. Wilsons here, maybe I could have been reassured that your life's changed, that you've turned things around in the last few years, and that you're on the right in the right direction. And I guess, not speaking for Mr. Duffer, but I guess that's the same thing that he's talking about. We're in a difficult position. I don't know that I have enough evidence today. I just wanted to make those comments to you, and I do appreciate Mr. Wilson coming and
Thank you.
that does go a long ways.
And I do appreciate Mr. Wilson, too, coming in today. That was very informative, and I do agree that is what I'm saying. One piece that I would have liked to have seen is your current employer here. That person would have known more about you on your day-to-day work. I didn't see that. Like Mr. McKinney said, if it had been more representation on your behalf, I think that would wait, in my opinion. Yes, sir.
Three things I wanted to point out is, one, Mr. Shackelford asked about the expiration date of his apprenticeship. That's October 31, 2019. Mr. Alexander, when he was talking a while ago, he said and I'm not sure you heard what he said, but or registered, he said that he had been denied an insurance producer's license. So a public record search on that shows that the original license was denied for cause on 10/31/2013. But Mr. Alexander did answer, have you ever had a license or applied for a license or its equivalent to practice any profession or occupation that was denied, suspended, or revoked or otherwise acted against? He did answer yes. Nothing in the narrative regarding that, but he did answer yes to that on the application.
I failed to mention, but that was another thing that gives me pause. Of course, this board is under the Department of Commerce and Insurance, and if the insurance department didn't feel comfortable in giving you a license, then that also makes me think a little bit more also.
More comments from any of the other board members? They want to welcome them.
Alexander, I would just ask you in summary, in your own words, share with us why you feel like you have these convictions on your record. And that may seem like a very broad and very vague question, but I would like to hear from you. You have given a description of the circumstances regarding each one of these convictions, but just in summary, in your own words, why do you have these convictions on your record?
I feel like that these convictions is on my record because of, I would say, kind-heartedness on the first one, trying to help my friend out, trying to be kind, but it was a wrong decision. Vehicle, the reason why this is on my record, I would say it's just something that an individual may would go through in life. Things happen, and you just can't, I couldn't pinpoint to say that I was wrong by doing this. I just can't say that I was wrong by taking my car, and that's on my record.
say that you knew that it was wrong to take a license plate off of a wrecked vehicle and put on that vehicle?
Yes, sir. I would. That was wrong. That was wrong.
Maybe a better way for me to ask that question would be, do you feel that any of these convictions were, for lack of a better word, deserved? Did you violate the law, and as a result you were convicted of a violation? Do you believe that any of these convictions were just or were deserved?
No.
In trying to consider all the factors, I do see positives and some negatives. See that Mr. Alexander has, I believe any man can change over time, and all made mistakes in our lives. When we were young, we made some, but Mr. Alexander has completed, or almost completed, his taking the courses and passed the exam. Plus, he has two substantial letters of recommendation from I too would feel a lot better if your current employee or employer had been here today to speak on your behalf. Trouble with the lack of evidence.
I'm having a problem with, I would think if you came before the board to get your license that you would be fighting for your life. And you're not prepared. You weren't prepared for this. You're not showing the board any evidence of rehabilitation. In fact, you just denied accountability for any of those convictions. You said you didn't think you should have received any of them. And that just doesn't sit well before the board, before me personally. I can't speak for the board, but I would thought you would have come in more prepared with, a voluntary community service affidavit, or your counselor. You told the board that you had one counseling session over the first account, and I just don't find that any of that's adequate. So I would not.
Any more questions to Mr. Alexander, Mr. Wilson, or the administration? Have a motion?
I make a motion that we deny the application.
We have a motion to deny the application from Mr. Alexander by Mr. Bridges. Is there a second?
Second.
We have a second by Mr. Shackelford. All in favor?
Aye.
Aye. Any opposed? Motion carries.
So the next step in this process is for the board to determine when the applicant may reapply for licensure. That could be immediately, or that could be a future date. Does the board wish to identify a date at which the applicant could reapply?
Are there any specific guidelines?
I think the board could just consider all the things that it's heard today, and if the board thinks that a particular date is appropriate for the applicant to reapply, the board could vote and determine that that's the appropriate date. If the board would like to just leave things as they would currently be, the board would decide that the applicant could reapply immediately. In deciding when the applicant can reapply, the board is not suggesting in any way that it would approve such application, but this is just part of the Fresh Start Act.
So by denying the application today, Mr. Gribble touched on the fact that the application would expire 90 days from the date that it was received. By denying the application today, does that render that null and void, so he must start again with a fresh application, irrespective of the fact that this application would not expire until 90 days from the date that it was received in the office?
That's correct. The board has voted to deny this application, so a new application would have to be submitted in the future.
If we set, or if we recommend another date, that's just a recommendation. He can still, do what he wants to. Is that correct? Or
I think technically he could do what he would like, but part of the Fresh Start analysis and the Act's requirements is that the board have a justification statement, and that's something that I will read into the record once we move past this concern, and that's part of it. So part of it is informing the applicant when he or she may reapply for licensure.
but is it? I'll just throw out if I said, if I made a motion that he could reapply in 1 year, is he prevented from applying in that year period, or does that just mean that we're just recommending that he wait a year?
I think, in effect, it's a recommendation.
Okay. So if I'm just thinking out loud, but if we say, or if we make a recommendation that he may reapply a year from now, and make also the recommendation that, when he comes back, that he brings more character witnesses, so to speak, or some further proof that he has made a change in his lifestyle. Is that something that's favorable to the board, or do you all just want to?
I think it'd be
just leave it alone.
Very important if there's some stipulations, if he has some more character witnesses, or his present employer, or someone that can better, convince a favor.
And the board doesn't have to determine a date that he can reapply. The board could say that he could reapply immediately, and that's essentially leaving things as they would ordinarily be.
Need a motion for that?
Yes, please. That'll allow me to finish the justification statement and read that into the record at the conclusion of this meeting.
I move that Mr. Alexander can reapply for his license immediately.
We have a motion on the table by Mr. Davis. Do we have a second?
My wheels are turning. In your motion, you made your motion so that, like in 2 months, that he could come back and bring character witnesses or what have you. Is that what you're thinking?
Or in 1 month?
Or whatever.
Immediately, whatever that is.
Okay.
Okay, so it could be the next board meeting or the one following.
Okay.
You all can.
Okay. Okay.
I do have one more comment here on this. And with the character witnesses, I think that would be huge for you, Mr. Alexander. I still am troubled with the piece that, your admission of you were not guilty of those charges. I think personally that you probably would want to seek that rehabilitation or that treatment, whatever that is, and have a little more evidence to present to the board.
Pastoral counseling.
And in my opinion, not just the character witnesses, but more to say I've gotten past that, for those 18 years. If you look at the span of it from 1998 to 2006, that's 18 years that you've had some mistakes that have happened, correct? How do we know that you've
turned your life around?
Correct.
I understand what you're saying.
That's just, I wanted to make that acknowledgement here on the record. We do have a motion on the table, as Mr. Davis stated that he could come back, Mr. Alexander could come back immediately. Do we have a second? So with that, the motion fails. Do we have a new motion on the table?
I'll jump out there. I'll make a motion that we recommend or suggest, whatever legal term we need to use, that you may reapply in 1 year, and then that'll give you time to whatever means that you think necessary to seek pastoral counseling, to get some kind of evidence back here that there's been a change made, bring more character witnesses, because just in my mind right now, and of course I don't think you're bound by this, you could still probably reapply anytime you want to, but I don't know that if you came back next month, I don't know that soon if my mind's going to change. But I'll make that motion that we recommend to him that he may reapply in a year, and just the suggestion that you bring a little more evidence or character witnesses with you when you come back.
We have a motion on the table by Mr. McKinney. I would like to ask Ms. Hooper, you ask a question, Mr. Kinney. Even though if this passes, would he be able to come back at any point?
He's not bound by this, or is he?
This isn't binding, but it's guidance from the board in its justification statement on when the applicant should look at reapplying for licensure.
Thank you.
It meets the criteria of the Fresh Start Act.
That's correct.
Okay, thank you.
Thank you. So we have a motion on the table from Mr. McKinney. Do we have a second?
Second.
We have a second by Mr. Bridges. All in favor? Any opposed? Motion carries.
So at this time, I will read the justification statement into the record, and after that, the board would need to make a motion to adopt the justification statement, and that would conclude the analysis of this application and the board's review. Here's the justification statement. The Board of Funeral Directors and Embalmers on January 8th, 2019 decided to deny the application for funeral director's license for Mr. Alexander as a result of 4 convictions. Conviction number 1, contributing to the delinquency of a minor on or about May 1988. Conviction number 2, for assault on a minor on or about May 1988. Conviction number 3, for vehicle theft on or about October 1996. Conviction number 4, for worthless checks on or about March 2002. The Board of Funeral Directors and Embalmers has decided to take this action after considering the following factors as set forth by the Fresh Start Act. Number 1, the nature and seriousness of the crime for which the individual was convicted. Number 2, the length of time since the commission of the crime. Number 3, the relationship between the nature of the crime and the purposes of regulating the occupation, profession, business, or trade for which the license, certificate, or registration is sought. Number 4, the relationship between the crime and the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of the occupation, profession, business, or trade. Number 5, any evidence of rehabilitation or treatment undertaken by the individual that might mitigate against the relationship of the crime to the occupation, profession, business, or trade. And number 6, any applicable federal laws regarding an individual's participation in the occupation, profession, business, or trade. If you wish to contest this determination, you may file a petition within 30 business days of the receipt of this notice in the Davidson County Chancery Court, at which time the Board of Funeral Directors and Embalmers must demonstrate by a preponderance of the evidence that the individual applicant, licensee, certificate holder, or registrant's conviction is related to the applicable occupation, profession, business, or trade. You may reapply for licensure 1 year from today's date. And that concludes the justification statement, so I would need a motion from the board to adopt the statement.
I'll make a motion to adopt the justification statement that was read into the record from Ms. Hooper.
Second.
We have a second by Mr. McKinney. All in favor? Aye. Any opposed? Motion carries.
Thank you. That concludes the analysis of this application and the Fresh Start process. Thank you.
Thank you, Ms. Hooper.
Thank you. Thank you for your patience as we kind of made our way through the process. Thank you for your patience also.
Yes, sir. I would like to say, I would like to thank the board and staff for your time and your recommendation. I consider that, and it might be a little bit before a year, but I will get these things taken care of because I think that'll mean a lot of weight to allow you guys to see that it's real. I thank you all for your time.
Thank you, Mr. Alexander.
Thank you for your patience. And thank you, Mr. Wilson, for being here today.
Thank the board for its guidance and the wisdom and the opportunity you've given Mr. Alexander. I appreciate you.
Moving on to the agenda, do we have any establishments?
No, Mr. Duffer, there's none today to appear before you.
Thank you, sir. Do we have any new business? Do we have a motion to adjourn?
So move.
We have a motion to adjourn. Do we have a second? Second. Thank you.